Senate will please come to order. The Senate will please come to order. All those not having privileges of the floor will please vacate the chamber. With those on the floor and our guests in the gallery, please rise as we are led in prayer this morning by the senior senator from the 8th, and then please remain standing as we are led in the pledge this morning by the senator from Jefferson, senior senator from the 8th.
Let's have a prayer together. Heavenly Father, we thank you again for another day. Thank you, Father, for this great state that we're all privileged to be part of. Today, as we convene this session of the Senate, Father, I pray for a modicum of wisdom. We pray for your grace and your guidance in everything that we say and do. I pray in the name of Jesus. Amen.
Amen. Senator from Jefferson.
Would the members of the Senate and guests in the gallery please join us as we pledge allegiance? I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. You may be seated. Reading of the journal.
West Virginia Legislature, Senate Journal, Charleston, West Virginia, Tuesday, October 2nd,
Senior
2018.
Senator from the 17th requests unanimous consent that further reading of the journal be dispensed with and that it be approved as having been read. Is there objection? Chair hears none, so ordered. Introduction of guest. Communications from the House.
There are none.
The hour having arrived for the Senate to sit as a court of impeachment, the chair calls the acting Chief Justice Farrell to the chair. With acting Chief Justice Farrell being absent, the court of impeachment will remain adjourned until its presiding officer is present. Reports from standing committees.
There are none.
Reports from select committees.
There are none.
Introduction of bills.
There are none.
Resolutions.
There are none.
Motions. Petitions.
There are none.
Unfinished business.
There is none.
Bills on third reading.
There are none.
Bills on second reading.
There are none.
Bills on first reading.
There are none.
Introduction of guest. Remarks by members of the Senate. Senator from Morgan County.
Thank you, Mr. President. At your request, I rise today to address the Senate with respect to the question of where exactly we are. I have the sense sometimes, when we're in a moment of great importance, and I think we are in such a moment. The prayer of distinguished colleague, the senator from the 8th, for wisdom is well made and well taken, I hope. Because I think we are in one of those moments right now where we will be judged by what we do, how we react, what we say to the circumstances in which we find ourselves. I have here in my hand the decision rendered by the Supreme Court of Appeals in the case of Workman versus Carmichael, Boley, Ferns, Cassis. The opinion was filed on October 11th, which was just last week, today being the 15th. In the case brought by Chief Justice Workman against the West Virginia Senate in the Supreme Court. I want to talk a little bit about the opinion, what I think it means, what I think is to be the proper and reasonable course of action for the Senate sitting as court of impeachment here in this extraordinary session of the 83rd Legislature of West Virginia. The court, and I know a number of you have read it, there's been some fairly extensive media coverage of the opinion, what it does, what it holds. As it relates to the articles of impeachment that were brought by and adopted by the House of Delegates against Chief Justice Margaret Workman, and there are, as members will recall, 3 of those, 3 articles of impeachment adopted by the House of Delegates that named Chief Justice Workman. 2 of those relate to the assignment of senior status judges to temporary service in the circuit courts of this state. The opinion, the decision of the Supreme Court as to those 2 statutes was to determine that the statutes are unconstitutional. And it flows from that, in the opinion, that any effort to remove anybody for, or to impeach, as the House did, a member of the Supreme Court for violation of a statute that is unconstitutional must fail. The court, and I will say this, for those of you who haven't read the opinion, I strongly recommend that you do so. I know for non-lawyers, legal reading is very dry sometimes, but I will give the Supreme Court credit, those assembled who read the briefs and wrote this opinion, credit for what I believe, Mr. President, was a bona fide effort on the part of the court to make a thorough survey of the applicable law and to in the opinion it crafted, give an exposition of its rationale and reasoning for the decisions that it made. Since almost the very founding of this republic, in the case of Marbury versus Madison, the opinion of Justice John Marshall, we have adhered in this country to the notion that the Supreme Court is the final arbiter of what is or is not constitutional. And it is from the state Supreme Court's perspective, its duty to address that question when raised. And so with respect to the assignment of senior status judges throughout the state, the court's opinion holds that under the West Virginia Constitution, the Supreme Court is given the authority to do that. And they are. It's in Article 8 of the West Virginia Constitution. Our state Supreme Court has authority to make temporary assignments of judges to the various circuits, family courts, circuit courts, magistrate courts throughout the state when there are temporary vacancies. And that happens sometimes. Judges get sick. Judges get occasionally suspended. Judges die. And in order for the judiciary to function for all the citizens of West Virginia, the court has the constitutional power to send judges into those circuits to hear cases when the duly elected judge is unavailable for one of those reasons. And that's what the court decided in this case. The court decided that its constitutional authority to make those assignments cannot be intruded upon by statute. And it held that the statutes under which two of the articles of impeachment that came from the House of Delegates were based made such an intrusion. In my opinion, as to those questions, that's it. The Supreme Court is the highest authority that there is on those questions. And not need to get into that now. They found, some other issues actually that have been raised by Chief Justice Workman as a respondent by motion in this Senate. There's another aspect of this opinion, however, that I must address. And we'll note that aspect of the opinion focuses on the processes that were followed in the House of Delegates leading to the adoption of articles of impeachment that were communicated to the Senate and upon which the Senate convened as a court of impeachment. In her petition for writ of mandamus to the state Supreme Court, Chief Justice Workman assailed some of those procedures as being either improper or unfair, outside the rules or resolutions that the House of Delegates had passed in connection with the articles of impeachment. And on that particular point, it seems to me that there is a problem. And to me, it's obvious what the source of the problem is. This case that was filed originally as a petition for writ of mandamus against the Senate does not name the Speaker of the House or any of the House managers or any of the other officials of the House of Delegates as a member, as a party to the case. So when the case was briefed It was briefed only by the petitioner, Justice Workman, her counsel, and counsel who appeared and filed a response on behalf of the Senate. And I think that has led to a problem. And let me see if I can outline it in a way that is going to be cogent and will make sense. Fundamentally, it is this, in a one-sentence description. The real party and interest on those points is not the Senate. You know, under Article 4, Section 9, our role in impeachment is essentially as a jury. We hold a trial and decide the question. Article 4, Section 9 of the Constitution says that the sole power of impeachment lies within the House of Delegates, not the Senate. And so to the extent that Chief Justice Workman's petition to the Supreme Court, and I think, you know, arguments, let me just say up front that the Chief Justice Workman has raised some arguments, and I won't identify which ones, which are non-frivolous. You know, there's serious, weighty legal questions. But to the extent that her petition called upon the state Supreme Court to review what occurred in the West Virginia House of Delegates and whether or not it was proper or appropriate, proper procedures were followed, the West Virginia Senate is not the right party to answer those questions for an adjudication. The briefs that were filed on behalf of the Senate and did not do that. They did not, try to defend on the merits the claims or allegations that were made by Justice Workman that proper procedures were not followed in the House of Delegates. And in my opinion, nor should they have. I know that all of us have taken our oaths as jurors for this court of impeachment very seriously. I know others, my colleagues whom I've spoken to here, made it an absolute point while the House was considering whether to adopt articles of impeachment. I made it an absolute point not to watch 1 minute of it. Not 1 minute of it. As it was being streamed, I believe it was streamed. You know, so I've told other people, you know, I'm in my 35th year now practicing law, and this proceeding has been my very first experience ever as a juror. And like all of us, I wanted to do it right. And I thought if the House does adopt articles of impeachment, and they're communicated to the Senate, and we are convened to be the trial jury for articles of impeachment as to one or more justice, I don't want my view of the presentation of that evidence to be tainted by something I saw watching proceedings in the House. So I have, and I think probably many of us, all of us, are in the same boat. As a senator, no firsthand knowledge and really no knowledge at all of the processes that were followed in the House of Delegates to create the articles of impeachment, which they ultimately adopted and communicated to the Senate. And so in a case that is styled as Chief Justice Workman, petitioner, members, officers of the West Virginia Senate as the respondents, wherein the Supreme Court is being asked to make a decision about whether or not procedures were proper as that action occurred in the House of Delegates, in my opinion, does not have the correct party before the court to answer those questions. As I said, the House of Delegates and its officers, its speaker and officers, managers, do not appear to be parties in this case at the present time. So, we'll talk a little bit about, we can say, well, Chief Justice Workman should have named the House of Delegates as a party to the case, or its officers. Maybe. Someone might respond, well, Senator Trump, the Senate should have moved to have the case held up or dismissed unless the House of Delegates were to be added as a party. If you believe they're an indispensable party, maybe. It's interesting the way this case developed. Interesting to me as a lawyer anyway. It started as a petition for writ of mandamus, asking the court to order some mandatory action. And so, in my opinion, it was not obvious from the beginning. The way the case was couched and brought, that the House should be a party. The court converted the case to a petition for a writ of prohibition. And a writ of prohibition is sort of the polar opposite of a petition for writ of mandamus. A writ of prohibition is a writ which the court has issued in this case against a party which says you must stop doing what you're doing. So in those circumstances, when the case was converted by the court, and let me just say this, I think the court's decision to convert it from mandamus to prohibition makes a lot of sense, given the relief that the petitioner was seeking. I'm not suggesting that there was anything wrong in the court's decision to do that, and there is precedent for it. To decide that one species of extraordinary writ remedy makes more sense in a particular case than another. So, but the case is recouched as petition for writ of prohibition. I think it does become obvious that the real party who needs to be before the court to address the questions that have been raised by Chief Justice Workman, and clearly, which, the court wrote about extensively, was not before the court. It was the House of Delegates. As I said before, all of us as members of the Senate have tried very hard, I believe, to adhere to the oath that we have, that we've all taken in the Constitution, to serve dispassionately as jurors, impartial jurors, decide the case. The oath is, our oath in the Constitution is to decide it based upon the law and the evidence. Now, if you read the court's opinion on that, if you read the whole opinion, you can tell that there is some frustration with the court, by the court. I don't know if frustration is the right word, maybe disappointment. Well, I'm not sure that's the right word. But there is a recognition throughout the opinion that the court would have liked to have had arguments, substantive arguments made in response to the arguments raised in the petition. The court actually says it 2 or 3 times in the opinion. And it seems clear to me that it's not, would not be appropriate for the Senate to do that. For the reason that, had this writ not been issued, what we'll be doing today is probably hearing the same arguments from Chief Justice Workman's counsel as to some of those points that she made, her counsel made, and argued before the Supreme Court. And we would hear them here, our presiding officer would hear them here, and we would hear the response of the House of Delegates speaking through its managers, its duly appointed managers, to each of those arguments. And our presiding officer would ultimately have made a decision, reviewable by the Senate, but would have made a decision on any of those that were raised and argued here in the Senate. And so our role in that respect would have been to review or pass upon, if we were called upon to do it under our rules, to review or pass upon the decisions made by the presiding officer for the Court of Impeachment, Judge Farrell. Instead, the way this case is framed, styled, the Senate is called upon to respond to those arguments before the Supreme Court regarding procedures of the House. And so, for the reasons I already outlined, the Senate isn't a participant in the procedures filed in the House, so we would not be, the Senate would not be the right party to make those responses, number one. But two, I think, as I think about it, and we are, let's be honest, we're in uncharted territory here. No one, it's been, I said it before, it's been 143 years before this year since there was a trial of impeachment in the West Virginia Senate. So, but in my opinion, and this is the opinion of just one senator, in my opinion, for the Senate to become the advocate for whatever position the House of Delegates might have, and quite frankly, we'd be guessing about what its position is as to some aspects of these challenges, but for the Senate to become the advocate for the Supreme Court as to the House's position in defense of its procedures would be in derogation of our responsibility to be impartial jurors in this case. So now that everyone is completely asleep, I apologize. But as you can tell, it is interesting to me. It is fascinating to me. And I'll go back to where I started and say, we are in a moment in time, a moment in history where it is incumbent upon all of us, and I'm not just speaking to the Senate here, I'm speaking about everyone, the judiciary, the House of Delegates, the executive branch. It is important that we all exercise deliberation, the best judgment that we can muster, because history will judge us for how we react, what we do in this moment. What should we do? What should we do? That is the fundamental question. I have an opinion, Mr. President. My opinion is this. I believe that we should ask the state Supreme Court to reconsider at least part of its decision. The decision I have in my hand rendered last week on October 11th. The part that relates to its adjudication of the propriety of the procedures that were followed in the House of Delegates. We were never the right party to make the defense of that. So the court procedures allow for a request for reconsideration. I'm told, I have not seen it, but I'm told that since this opinion was issued, another respondent, a former justice, Robin Davis, has asked that the writ be expanded, asked to join the case and that the writ granted by the Supreme Court in Chief Justice Workman's case be expanded to former Justice Davis. That apparently, if what I've been told is correct, that such a request has been made, the court is going to, in any event or circumstance, be continuing to grapple in one fashion or another with this case and with the issues that are framed by the pleadings in this case. So I think we should ask the court, the Senate, should ask the court to reconsider that portion of the opinion that addresses the procedures that were followed in the House leading to the adoption of articles of impeachment that were communicated to the Senate in August or September. And I think we should suggest to the court that the West Virginia House of Delegates is an indispensable party to that adjudication. You see, we're joined by the distinguished House Judiciary Chairman this morning and his staff. He is among those who've been appointed as the managers of the impeachments for the House of Delegates. And I'm suggesting that they might have something to say, some responses to make to the portions of the petition filed by Justice Workman, Chief Justice Workman, that address House procedures. And they are, the House of Delegates, in my opinion, the right entity, party, to do that. So I think we should ask for reconsideration of that portion of the opinion, and I think we should invite the court to add, or invite the petitioners to add, and invite the House of Delegates to perhaps intervene. And the Senate, ultimately, whatever happens, whenever any articles of impeachment come to the Senate from the House, we have a constitutionally defined narrow role. We are the jurors. We sit in judgment, decide whether to convict or not to convict based on those articles of impeachment, and it is not proper, in my opinion, for the Senate to be the party that analyzes or defends or assails, for that matter, what the House does. The litigants themselves may do it. They need to do it with each other. The litigants, in this case, we all of us keep dropping back to analogies to, traditionally framed civil criminal litigation cases, and they're never fully satisfying because this being the trial of impeachments is unique. But it does have similarities to other forms of adversarial proceedings, contest, litigation that we're all familiar with. The litigants are Chief Justice Workman and the House of Delegates. We're the jury. That'll be true with Justice Davis. It was true in the trial of Associate Justice Walker. So if we have a trial with respect to former Justice Davis, I think my colleagues already know where I am on that. I'll throw it out again as a gratuity. I don't think the Senate has jurisdiction to proceed with the trial of former Justice Davis or Justice Lawfrey. The Senate will not be a litigant. The Senate will be the jury. And the litigants are the respondents, and the House of Delegates, its duly appointed managers. I think the Supreme Court might, I hear myself utter those words, and it always causes me to pause, because when you try to guess, when I try to guess, my batting average is not very high. But I think the Supreme Court might grant the request for reconsideration, at least as to that aspect of the case. And the reason that I have some modicum of hope for that is because it's clear in reading the court's opinion, the court wanted to hear another side to the argument. It did. I mean, I think that's evident in the opinion. The court wanted to hear. I'm not talking about the questions of constitutionality of those statutes that relate to the assignment of temporary justices, senior status judges into counties where you have a judge who's sick or suspended. In my opinion, that part of this case and all the cases is over. The court has decided it. They are the final arbiter. But as to Chief Justice Workman, there is another article of impeachment that, is not tethered to that narrow question. Same, I believe, same with the articles that remain in place with respect to former Justice Davis, Justice Lawfrey, and the question of were the procedures followed by the House of Delegates proper or not is embedded and woven throughout all those cases. Not just Chief Justice Workman's case, former Justice Davis's case, Justice Lawfrey's case. Clearly, if it's true what I've heard, that Justice Davis has filed an appearance in this case and asked for the relief and the writ to be expanded to her, that could be both parts of what we've been talking about. It could have to do with the article of impeachment against former Justice Davis that relates to assignment of senior status judges, but it could also relate to this broader question of whether or not the House proceeded correctly in adopting and bringing to us articles of impeachment. So, Mr. President, you asked, that's my opinion. My opinion is that's what we should do. And let me just say this, we should do it in good faith. I believe if you read this opinion contains a serious effort by our Supreme Court as it was constituted for this case, a serious effort to survey the law, to consider really important legal arguments in a situation that appears before the court, if at all, once every 143 years. And I believe that our Supreme Court, the judicial branch of our government, wants, as we do, as the House of Delegates does, I hope as all the citizens do, that we get this right. Let's get it right. So I think there's clear evidence in the court's opinion that it was working very hard to try to do that. And that's why I think, a request to add the House, to reconsider, to add the House as a party to this, to get the House before the court, and let the House of Delegates make the arguments such as they may have. I don't know, but that they think, if they do, that their procedures were correct. That's the way we're going to get to a full and thorough adjudication of this. Not with the Senate somehow standing in as the arguer or advocate for the West Virginia House of Delegates. So, there you have it, Mr. President, the opinion of one little country lawyer senator from Morgan County. But I'll say that I think everyone, I hope everyone, shares this feeling that I have, that I talked about at the very beginning, that we are in a very important moment here. And it's critical. It is critical. Not just for the individual respondents in these cases. It's certainly critical for them, you know, the respondents who've been named by the House of Delegates. But it's critical for our institutions of government, all three branches. It's critical for the citizens of West Virginia. It's critical for the future. For those who will follow us and look back to see what we did or didn't do, it's critical that we get it right. And I'm not suggesting that the opinion is wrong, but what I'm suggesting is that the parties, the litigants who have everything at stake in this, the House of Delegates who's adopted the articles of impeachment, the respondents against whom articles of impeachment have been adopted, are the proper parties to square off, stand before, brief the Supreme Court as the real parties in interest. Thank you, Mr. President.
Thank you. Further remarks by members? Senator from Brooke.
Thank you, Mr. President. I have learned in this body that it's my opinion that if I follow the opinion of the country lawyer and senator from Morgan County, I'm usually in good shape. Mr. President, this past weekend I could find no better way to get over a Mountaineer loss than to sit down and read a 65-page legal opinion, and that's what I did. And I thought of it in terms of, as I looked through the implications that it could have for not just us, but future legislatures and how they deal with impeachment proceedings. And I'm concerned about the long-term effect that it may have over this body as well as the House. And I can't overemphasize the importance that I think that plays in all of this. And I'm concerned as I read through this that it represents an infringement potentially upon our ability as a legislature to hold public officials accountable on behalf of those that we represent. And I'm concerned that it threatens the checks and balances system of the three separate branches of government that are so important to us all. And I'm concerned that it transforms the judiciary into a branch that may be above the other branches of government. And I think that it does that by effectively injecting itself into the process, into the procedures of the House and the Senate, and in essence they would need the approval of the court system and able to impeach an individual of this government. Currently, only the House and the Senate, up until this order came out last week, are involved in impeachment proceedings, and that stems from Article 4, Section 9 of our Constitution, where it states that any officer of the state may be impeached for, and this is 6 separate grounds, for maladministration, corruption, incompetency, gross immorality, neglect of duty, or any high crime or misdemeanor. And importantly, the House of Delegates shall have the sole power of impeachment. The Senate shall have the sole power to try impeachments, and no person shall be convicted without the consent of 2/3 of the members elected thereto. When sitting as a court of impeachment, the President of the Supreme Court of Appeals, or if from any cause it be improper for him to act, then any other judge of that court shall be designated by it shall preside, and the senator shall be on oath or affirmation to do justice according to law and evidence. And that is it. That is the court as it's spelled out in our Constitution. That is their role in an impeachment proceeding. And there's no indication that the involvement of the judiciary is necessary, even contemplated, in the rest of the proceedings. And what I think is equally important, and a lot of us were involved putting together the Senate's rules, because there was no dusty binder somewhere in an office that said impeachment rules. There was no book for us to go by, and we worked diligently every side in all of this to put those rules together, because it wasn't historically precedent and set in stone what the rules were going to be, and we had to come up with those rules, and the House had to work through and come up with their rules, and I know that they spent a lot of time doing so. But when I looked at this ruling, they looked and saw that, and looked at the oath that we were required to give, and that was to do justice according to law and evidence. And that is how the court system asserted their authority to act and intervene in this case. That was the hook that they used, is that the law is what they were the sole arbiter over. And because of that part in the oath, that's what they took. And so by that, Mr. President, they then incorporated the rest of the Constitution of the state of West Virginia. And that incorporation then used the Due Process Clause, which is Article 3 of Section 10. And that said that no person shall be deprived of life, liberty, or property without due process of law and the judgment of his peers. And that liberty interest, to which the ruling talks about, is the reputation of Justice Workman as we move these proceedings. And I, like my colleague from Morgan County, I don't know fully what is contained within the articles. I made it a point to not watch what was going on in the House, because I think that a jury should go in with a clean slate, that they should only frame their decisions based on what they hear before them in the courts. And so the liberty interest that Justice Workman has in this case, is the ruling was that not having her reputation destroyed in the legal community and the public at large by being impeached. And they got to that, is that they based their conclusion on a 1977 case involving a civil service employee who had been suspended for 30 days. And they attached that case to the proceedings that bring us to this point and say that the civil case should be part of the political process as established by the Constitution. And that might be a legal leap. I don't know. I don't have the legal experience that many in this room have, but to bootstrap that case from a civil service case from 1977 into our political process seemed to be a little bit of a legal leap in my mind, Mr. President. So now the question would be, my concern, the long-term implications, is that any public official in the state of West Virginia that would be potentially impeached or has been impeached by the House, they just have to claim that the impeachment proceedings would damage their reputation in whatever community, whether it be the legal community, the state of West Virginia, because that was the individuals that they counted on to vote for them potentially in another election, that if they made that claim that it could damage their reputation, that would then trigger the court's involvement as to what brought us to where we're at now. And the court system would then become involved in what is the sole power of the House and the Senate. And just think about that. That it now is the court is the arbiter of what is proper between the House and the Senate, and the power that is given to us by the Constitution of the state of West Virginia. And simply asserting that assertion is what brought us to this writ and brought us to this point. And so, Mr. President, in closing, my concern is the long-term implications that we could face as this body by being under this rule. And how would this affect not just what we're doing, but future legislators down the road, and not being able to hold officials accountable in the state of West Virginia? I think that the senator from Morgan said a lot of things that pertain short-term to this case, and I think that he brought up a lot of good points, and the way forward that he proposed, I think, is the best way forward. That there was an indispensable party to that suit that was not part of that suit, and that's who needs to be heard. But my concerns, as I read through it, really focused on the long term, and I hope that we were able to fix that, and that the power can lie where it needs to lie in the state, given the Constitution. Thank you, Mr. President.
Further remarks? Senator from Harrison County.
Well, the gentleman from Brook yield.
Remarks?
Oh, no.
Yeah.
And I guess my friend from Morgan's not going to be able to yield either.
Correct.
I would just stand and I'm not sure exactly what was said here. I do understand what the gentleman from Morgan said. The gentleman from Brook, while I appreciate his comments, I think ignores the fact that impeachment proceedings, any proceedings of the government, cannot be unfettered. There was a time in this body when there was Senator Boley on the opposite side of the aisle from which I'm at. That does not mean just because these two bodies, any one party has the votes, that impeachment can be unfettered. That there still has to be constitutional oversight, and I think the gentleman from Morgan and I agree, and have agreed for a long time, that the charges of excessive expenditures for the senior status judges was likely unconstitutional because they had the Supreme Court has the constitutional right to handle its own budget. My question to the chair, or to Mr. President, in trying to decide how to move forward is, to what ends do we move forward? I believe that the House of Delegates could have intervened at any time in the proceedings before the Supreme Court. That's their right as a party. To go back and ask for that intervention now, to what end do we get to? The only article that's left is Article 14 that we sat here for days listening to the evidence on behalf of Justice Walker and the evidence against her, and came to a decision that really was not an impeachable offense. So to what end do we ask for the House of Delegates to intervene? And we have to ask ourselves as a body, why didn't the House intervene already if they had questions they wanted to answer in this matter? You know, I think the problem with this process started when our good governor told us to consider impeachment of everybody. Impeachment has to be circumscribed. We're fooling with our democracy. We can't come up with reasons or violations of law that don't actually exist. It's charged us to uphold the rule of law as one of the as one of the three branches of government. And I think it's being tested now. I think my friend from Morgan's words of being circumspect and that we will be judged on what we do from here is very appropriate and should be heartfelt. I know we're all political animals. I mean, that's why we're here, for one reason or another. But it's time now, after the weeks and the thousands upon thousands of dollars that we've expended in this process, to decide what really is the end game. What will we really gain by continuing on? And again, I put to the body, Mr. President, that if there was going to be an intervention by the House of Delegates in the matter before the Supreme Court, that should have taken place without us having to be the catalyst for that involvement. Thank you.
Further remarks by members. Senator from Cabell County.
Mr. President, I guess all we'll need is the senator from the 13th, and all the lawyers will have chimed in. Let me say a couple things, and I'll be brief. First of all, I respect my colleagues from across the aisle. They've made great points. Reasonable minds can differ when it comes to an interpretation of a 70-page court opinion, but I'm here to say a couple things. I think the court got it exactly right. I think they were deliberative. We don't have the legislature does not have an absolute right to impeach and remove. We couldn't impeach and remove a justice for being African American solely. We couldn't impeach a justice for being a Republican. We could not impeach a justice for being a woman. So due process kicks in here, regardless of what we think our indispensable part of the role in these proceedings is. So due process, as a guy that ran a grand jury back in the day, back in the 70s, I will tell you that the way a grand jury works is that you have the citizens, usually 17, 18, 19 people from the community. They hear evidence, and they return a true bill of indictment if they think the charge is sustained. But there's an oath. There are processes that must be followed. There's got to be an oath. There's got to be an indictment signed by the foreperson, and then you have an indictment, and then you have a trial. In this case, the Supreme Court is simply saying, House, you have the right to make your procedural rules, but you didn't follow the rules. You didn't follow due process. Follow your rules. And that indictment, which in my theoretical grand jury would be dismissed because procedure wasn't followed, and you go indict the person the proper way the next week, and you get justice. So I thought the court, really, I think that I'm going to have to be in disagreement for a moment with, my colleague, the Judiciary Chair. I think we waived, our lawyers did a great job, by the way, but we waived any right to argue there's an indispensable party here. We've waived that. We didn't raise it. Time's up. Opinions entered and done. We've waived that, in my humble opinion. I would just say that that's gone, and they're going to say it's gone. Great argument. I think if the House had been a party, we might have had a different response because they've never been heard on this procedurally. And I don't blame them for not intervening. I don't think that was appropriate. Would have been appropriate, but that argument's gone. I think what we are left with is if this is going to be pursued, the governor calls the House in, or if procedurally the House can call itself in, I don't know. Then, if they want to impeach somebody, impeach them, send it over here for a trial. We'll try the case, and we'll do what our consciences, tell us to do. Thank you.
Further remarks by members. Senator from Upshur.
Thank you, Mr. President. A lot of what I've heard about procedural this and procedural that, it's all the stuff that applies in a civil case or in a criminal case. And I think everybody in here recognizes that this is neither one of those. This is something that's a little bit different. In fact, it's a lot different. And so I'm always wondering, rules of evidence, procedure, and so on. We've established all these rules. In fact, the Senator from Brooke talked about participating in creating the rules and so on for this process, because this is a process that's done by the Senate as far as setting up the trial is concerned. And it's according to rules that are set up by the Senate, and it's according to judgment calls, even as to how those rules are going to apply in any particular case. That's something that the Senate and the members of this body determine, not the court. And that's pretty well established, I believe, constitutionally, that the House is in charge of what the House does internally within the House. The Senate has the same authority within the Senate. There's nothing unusual, for example, about a challenge to the chair. It doesn't happen every day, but we recognize that it happens, and we recognize that as legislation moves through either body, a challenge to the chair can be voted up or down according to the members, and laws are made based on whether or not the chairman of a committee determines a rule should be applied in a particular way, and whether or not the members of the body agree with what the chair has determined in that instance. How many laws are we going to overthrow if we're going to allow the court to begin to delve into the rules process of this chamber and of the chamber at the other end of this building? How many times are they going to suddenly start to inject themselves and say, sorry, you didn't follow the rules in the creation of that law? How many times are they going to come and second guess the chairman of a committee who says on a voice vote it passed or failed? How many times are people going to start to sue and say, no, he got that voice vote wrong, it actually passed, it didn't fail? That should have become law, or that shouldn't have become law. We can't allow the Supreme Court to interfere internally in our processes any more than we should really be interfering internally within their processes either. But what I really actually stood up to talk about wasn't specifically that. I just hear this being talked about it. Impeachment is not about the person who's being impeached nearly so much as it's about the public and the public's confidence in an elected official or in a branch of government or a body of government. And there's absolutely no question at this point whether every single charge is valid or not. There is no question, and I don't think anybody in this room can say that they can go back to their district and that the public expresses confidence in this court. There is no confidence in this court because the justices on this court destroyed that confidence. And what the power of impeachment is really all about is not conviction of somebody of a criminal offense. We can't even do that. We can convict them, but all we can do is toss them off the court. Because the power of impeachment is not about that. The power of impeachment is about restoring the public's confidence in an office or an institution or a branch of government. And what we know right now is the public has no confidence in that branch of this government. And what we're doing right now, if we allow the Supreme Court to interfere in the internal processes of the House and say they didn't follow their rules correctly, we're not restoring that confidence. We're not causing the public to say, well, at least they got that right. No. In fact, this whole process where we've allowed a Supreme Court Chief Justice who has herself been impeached to select the presiding officer of this, which we really have no choice in that constitutionally, but she selected the presiding officer over the court of impeachment. Then she filed an appeal because she's not just above the law, she's above the Constitution. So she filed an appeal, and then she picked indirectly the justices who would hear her appeal. And what the public is actually seeing out there is that they were right. This court is as corrupt as it could possibly be, but even further than this court being corrupt, the corruption clearly extends down further into the judiciary than merely the 5 people that sat at the top. Because they were able to pick, she was able to arrange to have picked 3 justices that decided her appeal in her favor. And they know that's corruption out there. They're not blind. And so when we talk about impeachment and we talk about restoring faith that the public might have in the Supreme Court of the state of West Virginia, what we're seeing is the destruction of that faith, not the restoration of it. We have a duty, every member of this body, just as every member of that body swore, to uphold, to protect, and defend the Constitution of the state of West Virginia. And if we're going to allow that court to usurp the internal workings of this body and that body, we're not keeping our oath. Not a single member of this body that's going to let that court inject itself into the individual processes to determine whether or not we followed the rules. I actually find it very telling that the senator from Oregon pointed out that even this decision that they made is all over the place in terms of its legal validity. The right people weren't even parties to the suit, and yet they still decided the way they decided. We're not allowed to, as they've said, we're not allowed, that's part of this decision, we're not allowed to look at their internal processes. We're not allowed to say whether or not they're following the judicial code of conduct. But they're going to delve all the way down into the farthest reaches of either one of these bodies to determine whether or not we have. They've completely failed in their ability to even put out a basic decision that's clear and comprehensive according to the law. And that's coming from our judiciary chair, who supports the decision in large part. But we can't question that. We're not allowed to question that. You know, the senator from Brooke is absolutely right. What they've done with this decision is they've said we're not a co-equal branch. We're the supreme branch. We're the branch that's over all the other branches. We'll tell you how to do it. And we'll not only tell you how to do it in general, we'll tell you how to do it in specific. The House gets to determine whether or not the House properly impeached. The Senate gets to determine whether or not we're going to have a court of impeachment and how the process is going to follow throughout. And frankly, as it says in our rules, every member of this body can be compelled to be present for the court of impeachment. And I believe that extends to the officer, the presiding officer of that impeachment. I think we have the right to demand that he appear. We have right in our rules that he doesn't get to make a decision that we can't question. In fact, we can overrule every single decision he made except the fact that he didn't bother to show up today, so we can't overrule his decision to not be here. Except that we can, because we have a sergeant at arms and we have the power to compel that man to be present and to do his duty as was charged to him. If he doesn't want to serve in that role, he should resign from that role, and we should demand that the Supreme Court appoint another person to stand in its stead. But we should not allow one branch of this government to usurp the power of the other branches. Thank you, Mr. President.
Further remarks by members? Further remarks? Further remarks before I recognize Senator from Harrison for a second time. Further remarks? Senator from Nicholas.
Thank you, Mr. President. I find it telling listening to all the arguments that we've heard here in the remarks over the last few minutes. One of the things that I know about this republic is that it has always been a struggle to get what's right. This process that we're talking about, the process of impeachment, should not be easy. It should be difficult. Why? Because when we talk about impeachment, we're talking about removing the will of the people in order to accomplish, to hold someone accountable in the whole process. I read through the dissenting opinion, the dissent in part and agree in part, and I've read most of the majority opinion that was issued last week in this particular matter. I find it interesting, everybody's brought out different points, and each, I I agree with in various forms and fashions. I think the senator from Morgan has presented to us some reasonableness about this process. I think the telling moment was when the Supreme Court, in looking at this particular matter, changed from a writ of mandamus to a writ of prohibition. Probably at the point that we were talking about early on in this whole process, is that the House didn't need to be a part of a writ of mandamus. But at the moment that it changed to a writ of prohibition, it calls for the House to become involved and to offer an opinion with regard to the process that they followed in order for us to be where we are today. This is difficult. It's a struggle. But it should be a struggle. It's the best way that we can get it right. I don't think we need to be rushing to an opinion or rushing to judgment on any particular issue. To do so is setting us up for a fall, but more importantly, right now, as a senator from Morgan illustrated, and I did too, I didn't watch the newspapers, I didn't watch the media, because I wanted to make sure that when we had the opportunity to hear all the evidence sitting here in this chamber, I did so as a responsible person who took my oath to rule according to the laws and to the evidence. The opinions did give me pause, and they still do, as to whether or not the judiciary has overstepped their boundaries with regard to where we are right now. But the decision is there. It's in our lap. We have to deal with it. I would encourage, Mr. President, that we do move forward in responding and asking for reconsideration of the opinion that was offered by the judiciary. I would also urge our members of the House to become part of that conversation so that we can make sure that the process that we follow in defending our Constitution, defending the Republic that we have, is the best decision and the right decision. Thank you, Mr. President.
Further remarks, the senior senator from Logan.
Thank you, Mr. President. I'm not a lawyer, okay? But I'm just going to say this. Because I remember when the investigation took place, not an investigation, when an investigative journalist basically brought to light the things that were going on. And I can remember when I stood up right here and I spoke about the fact that something needed to be done. And everybody said, he's running for office. He's just trying to beat his chest. That bothers me. That now, all of a sudden, everybody's fired up. When they should have been fired up in March. They should have been fired up in April, May, June. It wasn't until July, right before August 14th, when everybody started saying, oh, this is a horrible thing. I agree. But it bothers me that we select what we want to fight and what we don't want to fight. This was an issue that come out in February, and nobody on both sides said anything about it. And I find that to be disturbing. I'm still waiting on the investigation of the lobbyist who got access into our Capitol with an illegal card that was not his. Why are we being so selective? Thank you, Mr. President.
Further remarks, the senior senator from the 15th.
Thank you, Mr. President. I want to address a few things here, and a lot of it's been said. But when I was packing my luggage to come down yesterday, you know how we all have bushels and bushels of paper in our home? Well, I ran across this, and it's dated August the 10th. And it's from the Senate President, and each one of us received one of these. And it's talking about, as public figures, you may be asked by the media outlets and other entities to comment upon consideration of potential impeachment proceedings. Please be cautious in your approach to such inquiries and fully recognize that, as a senator, you are designated by the West Virginia Constitution as a juror in an impeachment trial. I won't go any further on that, but that was the gist of the whole letter, was to make us aware of that. When we finished up with the Walker trial, I was very, very pleased. I was actually proud to be a senator at that point in time, not a juror. And the reason for it is there was 32 votes that did what I believed, the same things what I did. And I had conversations with some of you afterwards where I took the articles of impeachment, and as the trial was going through, you'd hear testimony from one side or another, and I'd draw a line through and say, not applicable, or not guilty, or whatever you want to use. And that's how I went about going down through it. And when we got to the very end of it, there was one little spot that I had a question mark on that fell into that category. And if you got a question, you can't convict if you're not saying, yes, this is a problem. But we in here as a body, I was proud of us. I think I could be proud of us if we traveled through into the next impeachment and the next impeachment, because I'm quite confident of the members that I serve with in here of being excellent jurors, because I witnessed it already in the first trial. Hoppy, or West Virginia Talk Line, had Margaret Workman on. And I heard it, and I got ready to turn the station off. And the reason I turned it off is because I didn't want to be affected by it. So I texted Hoppy, and I told him, I said, for the record, I just turned you off. He texted me back a little bit later and said it was a really, you missed a good interview. Like that. And I said, well, I'll get to hear it again under oath. And it's the truth. That's what I anticipated hearing. Is coming into the future. I share the same concerns as the senator from, I forget your, Senator Carnes, I'll just put it out there, on that. Look, back in the district, what I heard over and over was impeach them all. I never heard anybody say be deliberative or anything like that. The public was saying impeach them all. That's not our role. And we haven't behaved that way. That's not our role. But how this court was appointed and what's going on bugs me. And, you know, everybody knows that West Virginia, until just recently, has been on the judicial hellhole. But there's a reason for that. Some of it was legislatively what we had on the books. Some of it's got to do with our court system. And I'm going to give you an example of one. And it's right to work, Judge Jennifer Bailey. The injunction was taken care or overturned on September the 15th of 2017. Put it back into the lower court from our Supreme Court. That's over a year ago. And it was the preliminary injunction was August the 10th of 2016, over 2 years ago. I'm not a lawyer. I'm a small business guy. But I can tell you right now that business people actually pay attention to that, Mr. President. It says there might be something wrong with our court system. We're in the business of fixing the state of West Virginia, and it's a continuous process, because no matter what laws that we pass, they may become obsolete, outdated, or a deterrent, or not have the original intent 1 year, 10 years, 20 years later. That's why we keep coming back, to adapt to the times. This is sort of what we're talking about here. And by the way, for the record, the plea agreement that came in to this earlier, where again, the jury, in my mind, we couldn't accept it no matter how it came at us. I don't care what motion, what resolution, or whatever else it may be. We couldn't accept it because not one time, and one of you 5 lawyers that are in here stand up and tell me when you've ever seen a jury participate in a plea agreement. I want to know about it. I could be wrong. Again, I've never sat on a jury before. But I do know this much, no matter who comes in before us, they're going to get an honest trial. And if you're not guilty, you shouldn't have a thing to worry about. Not a thing. Because I trust the members of this body. And remember, you got to reach the 2/3 threshold. And I'm certain, whether you're a Democrat or Republican in this, there's 2/3 of us guaranteed are good people and good jurors to make the right decisions no matter what comes before us, regardless of politics. I guess I stood up more than anything here to make it so that the public could also hear what was going on, but also to let my fellow members know that I'm proud to serve with each and every one of you because of what we've done so far. Thank you, Mr. President.
Further remarks? Further remarks by members who have not spoken. I'll recognize Senator from Harrison for a second time.
Thank you, Mr. President. I have to stand and defend what I've lived for almost 3 decades, which is the rule of law. You hear it all the time, we're a country of laws. The rule of law. Those are words to most of us. Don't really know what the rule of law means, what due process means, how important it is to the foundation of our country, of our state. It's our democracy. It's what makes the republic. Because without the rule of law, there's chaos, there's anarchy, there's mob rule, where the clamor of the masses cause hangings in the courthouse square without due process, without a finding whether somebody's legitimately charged and legitimately guilty. That's what we're faced with here today. The courts are the arbiter of the rule of law. We don't always agree with them. I can remember back to when my friend, the former senator from Logan, switched parties and the governor, there was a question whether the governor had to appoint his previous party that he ran under or the current party he was under when he resigned. I didn't agree with that rule of law. I thought it was wrong, but I respected it. I didn't challenge them as trying to usurp the power of this body. I didn't challenge them as not looking at our Constitution correctly, because it's the rule of law. Going back to Marbury v. Madison, going back to Plessy v. Ferguson, going back to Brown v. the Board of Education, you don't always agree. But in our country, we accept the rule of law because it's the foundation of the law. It's the foundation of our country. I know your emotions tell you to get up and rail against the courts when you don't agree with them. Judicial hellhole. That's a made-up line from the U.S. Chamber of Commerce. Our judiciary is no different here than it is in any other state. In fact, it's probably one of the best. We have some of the lowest number of lawsuits per citizen, but that doesn't have a place here. That's not what we're talking about. We're talking about whether we agree or disagree with the Supreme Court's ruling on 2 issues. One is the senior status judges. That's done. We cannot constitutionally challenge how that branch of government spends its money. But we took steps to fix it, because on the ballot this year is a constitutional amendment that's going to allow us to oversee their budget, which is how the process works. We've corrected that. You have fixed that, my friend from Berkeley County. You have fixed that by putting that on the ballot. And so we're going to let the people decide. But to stand up and allow the mob to yell and scream that they need a head in the courthouse square in order to be satisfied, it shows we have no courage. It shows we have no principles. To not follow the rule of law is to turn your back on our Constitution. Turn your back on the separation of powers, because it is the court's job to be the arbiter of the law. It is their duty to decide what is constitutional and what is not constitutional, because without due process, none of us have any defense. None of us have anybody to look out for us but ourselves. And that is when you become a country that is not the guiding light for the rest of the world, but simply another country in the mess of the rest of the world, where the people have no control over their own destiny. Thank you, Mr. President.
Further remarks? Recognize the senator from Upshur for a second time.
Thank you, Mr. President. You know, I couldn't agree more. The rule of law is the foundation of our republic. And what gets missed is that the rule of law is what's written down. It's not five guys' opinions or five gals' opinions or whatever the mix might be. As was pointed out again, I'll note the senator from Brooke, what the Constitution says. The rule of law, what the law says, because the Constitution is the highest law in this state. It says that the sole power of impeachment lies with the House, and that the trial of impeachment, the sole power is here in this body, the Senate. This isn't the rule of law. This decision doesn't represent the rule of law, because the law is plain. This represents a branch of this government. You know, a few minutes ago, again, the senator from Harrison mentioned the idea that nothing can be unfettered. We can't be unfettered in our impeachment power. But that's exactly what this court has declared, that they're unfettered. We can't fetter them. That's essentially what that means. That means that they're, again, above us. You know, the average person out there, they see the courts as something that's up here above them. They see the law as something that's up here above them. They see these judges and prosecutors and defenders and everything in that courtroom, and they hope they can reach high enough to get their justice out of that court system. But what we have here is a collection of justices that see the law as somewhere down there, somewhere so far beneath them they don't even recognize it anymore. Something that is simply to be used to further their own selfish agendas, to maintain their power, to maintain their position. This isn't about mob rule. The senator from Berkeley pointed out, you know, we've already had a trial. I'm not up here advocating that anybody be automatically convicted, but our right to have the trial can't be questioned. That's the difference here. We'll hear the evidence when we have the trial here. We've heard the evidence in one case. There was no issue with people listening to the evidence, and there was no question that we had a right to hear the evidence. This is a declaration, again, by people who are so far above that law down there that they're not even going to let us hear the evidence. That's their declaration. We can't be trusted to even hear the evidence. They're not going to allow for that, because we're all so far beneath them. We're all so far beneath that branch. You know, this is not mob rule. This is rule of law. This is the Constitution clearly says. If we're going to cause the people of West Virginia to be able to have confidence in this body and in the body at the other end of the hallway and in that court and the governor's mansion downstairs and all the other constitutional officers in this state and the magistrates and so on, they have to see that there is accountability for whenever officials act in a bad way. You know, I keep hearing how things have been so wonderful in West Virginia. We haven't had to even really seriously go after impeaching anybody for 140 years. It's not because we're somehow pure and undefiled. We have a different impeachment process in West Virginia. Our history of corruption in West Virginia has determined that we only have one real impeachment process. It's called a federal indictment. That's how you leave office in West Virginia. This body and that body has not acted responsibly in the past when people were clearly in violation of the law. I guess they were afraid of being accused of mob rule, so we've allowed the federal government to come in and be our impeachment process. Virtually every official in this state has been impeached at one time or another by the federal government, whether it's the president of the Senate a few decades ago, or governors that have spent time in federal prison, or county clerks. Virtually every official in this state has spent time in federal prison, representing every office in this state, because bodies like this body have not stood up and followed the rule of law. because there was an old buddy system or whatever the system was. We have a responsibility here to do our duty according to the Constitution, and it hasn't been done in the past. 140 years is not the result of doing our duty. 140 years is a result of abdicating our duty. And I'm simply saying that we should stop. We made a change 4 years ago that we said we're going to do things differently in this state, that we're going to operate differently, that we were going to build an economy, that we were going to end corruption, that we were going to rebuild our school system. And this is part of that process. Are we really going to take seriously what we told the people of this state we were going to do when we took control of the process? Are we really going to act according to the rule of law? Or are we going to allow people to just deliver their own self-interest in whatever way they want? Are we going to allow them to truly be unfettered? Thanks, Mr. President.
Further remarks by members. Further remarks by members. Senator from Ohio County.
Thank you, Mr. President. Subject to announcements, move the Senate stand adjourned until subsequently called by the President.
Senator from Ohio moves that the Senate stand adjourned until subsequently called by the President. Yeas and nays have been demanded. Is the demand sustained? Demand is sustained. All those in favor of the Senator's motion will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, there being 29 yeas, 1 nay, 4 absent, not voting, more than a majority of those present and voting having voted in the affirmative, I declare the Senate adjourned until subsequently called by the President.